A very warm welcome, good morning to all the participants, all the legal practitioners, law students who have joined us from different regions of Maharashtra. Thanks a lot for being on Sunday Law Bulletin session today. It's a pleasure to have each one of you with us here today. As we start with SLB, here's a brief intro about LDF. Lawyers Development Forum, as you all know, is a forum which actively promotes camaraderie within the legal community so that it can enforce learning spirit within the legal fraternity. It brings together advocates through a blend of different sessions, such as these academic sessions, SLB sessions, organizing workshops where esteemed judges and different expert speakers from different domains come and attend and they deliver sessions and share their insights. Of course, this is our signature initiative, as you all know, our Sunday Law Bulletin. This has become the trademark for all the LDF events or all the weekly events that we conduct. But altogether, today we'll continue forward from the previous session, and we have with us the eminent speaker, Advocate Archana Kadam, ma'am. Before we commence, here's a brief instruction about another event that LDF is hosting. We all know that LDF hosts also sports events such as badminton tournaments and cricket matches. On the similar lines, I'd like to share one important instruction as received from the seniors. Give me 1 minute. As you all can see, we have LDF women's cricket team. We'll be soon launching it, and for that purpose, we would invite registrations from all the interested women advocates who are willing to register and participate and be a part of this team. There'll be selection trials, and of course, there'll be coaching which will be offered. So I request all the members, female members of the legal fraternity, to come forward, register their names, and as you all can see, registration and inquiries will be handled by our coordinators. And if you at all want to get some information about it, it will regularly be posted across all the LDF groups. At the same time, in the chat box, I'll be sharing the numbers of the coordinators as well. You may contact them, or you can directly join LDF's team, where we regularly post such instructions. The last date for registration is 15th August. Post that, we'll not be having any inquiries entertained. So come forward, step in, and have a look at all the new exciting opportunities that LDF is offering for all the women in the legal fraternity realm. So with that, let's now quickly move forward with the session. Ma'am, you may now kindly continue because I'm running. I think I've eaten up your time, so you may
No,
now.
no, not an issue, not an issue. Thank you, Ruchi Madam, so much. And thank you, LDF committee members and the co-founders of this Lawyers Development Forum for giving me privilege on this platform to share and address this very wonderful and very exciting topic, that is the maintenance, which is nowadays very much in hype, and at the same time, a lot of litigations are pending. And because of some inefficiency within our advocates also, if we are not well read with the what are the quantum, how to decide the quantum, or we are not able to line up all the credential evidence before the honorable court, then these litigations go on pending. And it is our duty of as an advocate also, and as later in other forums, if we have good knowledge and expert, it is our duty to share to all the budding lawyers who have just fresh pass out, and even some seniors who are practicing some other expertise, but still then some due to some of whatever reason they take some of the patrimonial proof, which way they rarely take it. And sometimes it is very difficult if they are not well read or not accustomed with the latest development happening. Especially last lecture, part 1, we have gone through in detail about the Rajneesh versus Nia, which is very much, it is a mandate before filing any maintenance before the any court. It is mandate to read all for all the lawyers to go to this. So in that, we covered regarding issues regarding overlapping jurisdiction, we regarding the payment of interim maintenance, and what is a permanent element, and how the balance approach is taken up by the court, and how this enforcement of execution of maintenance orders are done through Rajneesh. And later on, with that same Rajneesh versus Neha was a Supreme Court judgment which was in the year 2021. Further in 2020 through BNSS 144, which was previously corresponding to section 125 CRPC. In that also we covered all the basic section regarding, it is in chapter 10, 144 to 147. In last part, we have covered all that. I think it is being recorded and it is being downloaded by LDC team, Lawyers Development Forum team, LDF. And in that also we have seen last recap is like what is the disqualification and cancellation of those maintenance under section 44 of BNSS. Regarding the relationship with the personal laws we also covered, and how Rajneesh versus Neha, all the guiding principles laid down in the section 124 while deciding the quantum of the relief. And what about we have also covered what was the nature of proceeding in BNSS, what type of proceedings can be filed into this court, that in detail. If you have not attended this lecture last time, you can go on the website of LDF Forum Sunday Bulletin last Sunday, which we have completed, and look at. And in that lot of case laws also, there you can nicely see it. And we also covered one very important aspect. What do you mean by sufficient means? Sometimes this is a point very much required to be known by. Sometimes we fail in this and our maintenance applications remain pending, or we are not able to give a proper justifiable amount to our clients. So what happens then? Those are gone into appeal, then in go to Supreme Court. If we do it at a trial court itself, if we apply our mind very properly, when again and again lot of Supreme Court judgment are being passed, and which we have covered in our last lecture. Please go to those last lecture of Sunday Bulletin of on LDF, which is done. And we also covered what are the sufficient reasons for wife separate residence, that is a subsection 4 of 144 that we have covered, and unable to maintain herself regarding delay in claiming in after divorce. Then what are the rights of the second wife? What are the effects also covered in 144, effects of remarriage after filing of application, that also we covered. And then what are the standard proof of marriage required? What is a living in adultery means as per the 144 and corresponding section 125 CRPC? And what are the procedural aspects regards like jurisdiction, recording of evidences, then the power of award, then alteration of the allowances, and the cancellation of order in specific cases, and how the enforcement of order maintenance can be done. This is all done in the previous lecture which we have done. For that, if you have not understood, or some person who have not attended that lecture, please go to that first. Today, our lecture is part 2 and part 3 will be coming next Sunday. Then that today's lecture, we are going to cover only Hindu Marriage Act, maintenance under Hindu Marriage Act 1955, and the maintenance under Hindu Adoption Maintenance Act. Fine. This is the today's two topic. In the next lecture, we are going to cover the maintenance under Domestic Violence Act, maintenance as per the Muslim Personal Act, and what are the bars regarding all these release. What are the bars laid down by the Supreme Court judgment, or some of the acts and the provisions which will be dealt in detail in the next bulletin. And it will be 15 minutes will be interactive session with all of you regarding part 1 and part 2 what we have done. And in that, if you feel there is needed something, or some queries are still remain unheard, then we will next part of the lecture last that we will covering between 10 to 15 minutes. So let us start with our today's part 2 lecture, which we are intent. So basically, Hindu Marriage Act, though we have covered regarding the maintenance of the previous, it is somewhat same only, but little bit here and there small changes which is being done, which we will. Basically, maintenance means what? On what route it is being guided? It is based on equity, fairness, and the social justice. Maintenance basically a social. Why it is told as social justice? Why? Because during the matrimonial, when the matrimonial relationship is dissolved by a decree, the consequences are not only emotional, they are also deeply rooted to economic. Suppose it is like one spouse is sacrificing her own career opportunities once she come into matrimony. Sometimes it is a financial independence, and sometimes her earning capacities, because to furtherance of the matrimonial partnership. Because any matrimonial is a partnership between the two human beings living a well-being life for her, for themselves, and if they are bringing 2 kids, they are also, their well-being is also dependent on them, and the well-being of the other people, like their father, mothers, and wife's father, mother, and everything, whole family come into consideration. So in the Hindu Marriage Act, under Section 24, in this act provides a maintenance pendulite and the expenses of the proceedings. So what does Section 24 provides us? One is the expenses of the proceedings and the maintenance pendulite. Whether Section 25 is only for women? No, it can be for woman, wife also, it can be for husband. We will understand this in a nice way with the case laws of the Supreme Court judgment. What is the expression pendulite means? It means pendulite basically means pendency of litigation. Suppose husband filed a litigation for divorce, or a wife, vice versa, wife filed for litigation for divorce, then till the divorce can't be instantly decided on the merits. So till that pendency of that litigation, a small interim maintenance or pendulite maintenance is given to the either of the party, whether it is a husband or a wife. So court empowers the court to interim financial support. It is basically maintenance means what? It is a support to the either of the spouse, wife or a husband. Okay. It appears that no independent, see why, when this support is given, when the independent income sufficient to his or support and to meet the necessary expense is lacking in any of the spouse, that is time court comes into consideration to decide one quantum based on the factual financial status quo of either of the party. So under Section 24, what do you mean by reason? Means within how many days it has to be disposed? It is as per the sections, as per the section, it is decided. It should be decided within the 60 days from the service of the notice on the opposite party. So this is 60 days. Within 60 days, it should be disposed of. So if you want to really understand the support, meaning of support, as per the, you can kindly note down if you are having paper or something like that, Manish Jain versus Akanksha Jain. So, the case law is of 2017, Supreme Court 801. Here the Supreme Court clarified that term support under Section 24 must be understood as a maintenance pendulite. The object of provision is to ensure what? To sustenance and reasonable living during the pendency of the matrimonial proceedings. If suppose if the both wife is living separately, she can't just be told to, okay, you live on yourself. No, she was living with accustomed to one lifestyle when she was living with her husband along with the kids. Then their expenses and all those will be come. So that is why that reasonable living during the pendency of marriage has to be granted by the husband. It can't be cut short. How, from where she will maintain the children? So those all aspects of amount will be, quantum will be decided in our maintenance pendulite. Now we have to see what are the limits and the judicial discretions which our judiciary applies. Your scope of judicial discretion under Section 24, you can note down a case, a very beautiful case, Amarjit Kaur versus Harbhajan Singh, 2003, Supreme Court 228. In this case, wife sought interim maintenance during divorce proceeding. While the High Court granted maintenance, it imposed a condition. What condition was imposed? The wife has to undergo a DNA test of the child in her custody, failing which she will lose her entitlement to maintenance. Is it right to lay this type of conditions? No, in Section 24 doesn't allow that. So what Supreme Court held in this case? She told nothing doing. This condition is impermissible. It observed that only statutory, what are the statutory conditions under Section 24 is whether the applicant has an independent income sufficient for the support and the litigation expenses. That has to be taken care of in under Section 24. You can't put another separate condition, do the DNA check, this, that. That is not allowed. Supreme Court, it is impermissible. Once this condition, if the condition is satisfied, like the applicant independent income is not sufficient for her support and the litigation, as she is not able to bear those litigation expenses, then court has a confined jurisdiction to determine the reasonable quantum. confined discretion. These words are from the Supreme Court judgment ruling. It cannot impose extraneous condition that have self-defeating consequences. Why this is self-defeating? Because DNA, if it is asking for DNA, then it is self-defeating, or that pertains to issues to be adjudicated in the main matter. If you want to adjudicate, then decide in the main matrimonial, but you can't decide it under section 24 of the matrimonial relief. Clear? Now we will go, what do you mean by the financial? Now the capacity of the person should be realistic, and that assessment has to be done by the advocate, which is given by their own client, and it is being has to be nicely analyzed by the judiciary itself, by the honorable judge also. But sometimes what happened, due to paying of this husband, sometimes if husband is supposed to pay maintenance to the wife, he try to conceal his income. If he is doing some business, he will try to take all the cash entries. Previously also, if they are doing some business, there is a possibility their income is not totally on the books. It will be off the books, which is not having written. Then it becomes very difficult for the judiciary to find out what will be exactly the quantum, and wife is unable. Sometimes how you can as an advocate, how will able to overcome these demerits or this type of flaws which are happening real will do when this type of things, suppose is a partnership in the family business and nothing income is all shown in the one institute of the family, and in that also they are not showing all the component, check amount also little is shown and the cash component. Then in that you have to determine the lifestyle. Suppose they are having their vehicles expenditure, you have to find out what is. Based on that you can co-determine their income also, even if they are not showing it. So this is a small hint which I am giving. So here I will try to explain this point. This principle governing the realistic assessment of the filing is by Rita Dutta. You can read Rita Dutta versus Shubhadeni Dutta, 2005, Supreme Court 619, SAC 619. Okay, everybody noted. In this case, the husband initiated divorce proceeding alleging cruelty. The wife sought interim maintenance for herself and her two sons under section 24, right? Claiming that she lacked sufficient means. While the husband was earning substantially as a professional architect, the husband, however, disputed his income and alleged that wife had independent earning through home-based sari business. The trial court disbelieved what happened? Disbelieved the husband disclosure and granted the maintenance to the wife. Then he went to High Court. The High Court, however, denied the maintenance to the wife. He denied. In High Court, when he appealed, he denied maintenance to the wife on the assumption she had an independent income and reduced the maintenance granted to the elder son. Okay, on this, upon appeal, then again it was appealed in the Supreme Court, that is through this Rita Dutta versus Shubhadani 2005 Supreme Court judgment. Upon appeal, the Supreme Court held that mere existence of a small home-based business or ownership of a residence does not negate the need of financial support. Even if the spouse has a roof over her head, she may still require financial assistance for the daily expenses, medical needs, and the educational requirement of the children. Is it clear from here? Then last, what is accordingly? Supreme Court modified the High Court order and directed to grant interim maintenance both to the wife and the son. Your son is not a minor. He is about adult. But he is not having means to take care of his further studies. The court fixed the total maintenance at rupees 7,000 per month, payable from the date of filing of section 24 application. Hope this is clear. Then if you are clear, we will go to the one more term is assessment of income. How you judiciary, how they assess the income, what is their mindset, what is their status, how they assess, and how is the responsibility being distributed to the people. Here, Srimati, we will take up a case, Srimati Jasbir Kaur Segal versus District Judge of Dehradun. Okay, Srimati Jasbir Kaur Segal versus District Judge Dehradun, 1997 case, SCC 7. The parties were married in 1963. Here, the husband, a retired lieutenant colonel who later served as a director in ONGC, filed a petition for divorce under Section 13 of the Act of the grounds of this Hindu Marriage Act, ground of cruelty and desertion. During the pendency of the proceeding, the wife applied for the maintenance pendulite under Section 24. The trial court granted 1,000 per month, which was enhanced by the High Court as 1,500 per month. Dissatisfied with that, she described a paltry amount. The wife approached the Supreme Court. The Supreme Court observed here that the wife had no independent source of income and she also maintaining her eldest unmarried daughter. It held that Section 24 cannot be construed narrowly to mean just maintenance of the wife alone, particularly where she bears a responsibility of maintaining a dependent children. The factor court stated, this factor the court stated, it must necessarily be taken into account while determining interim maintenance. The court therefore scrutinized the husband's affidavit regarding his whole income statement. This affidavit is given of income and asset. It found that disclosure was incomplete and evasive. So as an advocate, we should be very, very careful when we do a disclosure on the affidavit. It should not be evasive or incomplete. Second, it warranting, that is why it warrant a adverse inference, because the incomplete and evasive affidavit was given. Adverse inference was drawn from that. Recognizing the practical difficulty in accurately determining income, the court observed that some degree of conjecture and reasonable estimation inevitably entered into this. So here what they have done, they done the reasonable estimation. Maintenance cannot be calculated with mathematical. What they said in this case was maintenance cannot be calculated with mathematical precision, or straight jacket formula cannot be put for the calculation of the quantum. So therefore, this court laid down guiding this principle for fixing maintenance under Section 24 is there is no rigid formula can be prescribed. One. Second, court must consider the status of both the parties. Third, irrespective needs, the respective needs has to be also be evaluated. And the fourth is the paying spouse capacity, including statutory deduction, unavoidable expenses must be taken into account. Importantly, court emphasize here, maintenance must enable the wife to live in a what? Reasonable comfort, consistent to the standard of living which she was accustomed to during the marriage. What she was living the lifestyle. Suppose she was living a lifestyle of expenses of around 2 lakhs, then definitely she should be granted 2 lakh expenditure for her maintenance. The object is not mere subsistence, it must be dignified sustenance. Hope this is clear regarding the maintenance assessment, how they assess, what is the status and what are the responsibilities. Okay, if we are clear with this, then now we will come to the point where both spouses are employed. So many times this becomes a problem, and many times it is helped also, and there are two contrary judgments are based. It is all judgments are based on states and facts of the each different cases. Here we will take a particular one Supreme Court judgment where there is an interim for where both parties are income and both parties income is being assessed. It is Anu Kaul versus Rajiv Kaul, 2009 Supreme Court, SCC 209. In this case, what happened? The husband has filed an appeal before the Punjab and Haryana High Court challenging a decree passed by additional district judge. During the pendency of the appeal, the wife filed an application under Section 24 seeking interim maintenance of rupees 10,000 per month and litigation expenses rupees 22,000. This was the application for interim maintenance. Then the High Court granted 10,000 towards litigation expenses and 2,000 for the maintenance of the minor child residing with the wife. This because since both husband and wife were working, dissatisfied with this limited relief, wife was dissatisfied, and then what is nothing doing? I'll go to Supreme Court. She went to Supreme Court. Before that court, it was asserted that the husband was employed as a senior head of Mukund Steel Limited, drawing approximately how much? 40,000 per month, along with the educational perks. Along with the salary, he had some perks. Every company provides you some perks, some traveling perks, educational perks, maintenance perks, all this. Notably, this assertion was not denied by the, and this assertion was not denied by the husband. He said, okay, but he failed to file a reply or a counter affidavit on the same. At the same time, court took into account that wife herself was employed and earning 9,000 per month. She was paying a rent of rupees 3,000 per month, and the child educational expenses were increasing due to the rising cost of schooling. The Supreme Court declined to enhance. Supreme Court said, I'm not increasing your interim maintenance payable to the wife personally, because since she is employed and earning a good salary, no further enhancement was warranted. But however, the court found that amount awarded for the minor child is very inadequate. Taking into consideration the father's financial position, the fee structure of the schools, good schools, and the general cost of living, the court enhanced how much child maintenance from 2,000 to 5,000 per month, paying during the pendency of the appeal. Okay, got it? So here lot many concepts got clear. Like when the husband and wife are there, then what are the concepts? Basically, what is it? Both people, spouse income is taken into consideration in this code, which is being covered. Then what are the expenses of the children, real expenses of the children, that are be considered by the court, and then only court have given her awarded the enhancement of the child maintenance, and maintenance to the wife is not given. Now, we will go to another section of maintenance, that is permanent alimony of maintenance under Section 25 of Hindu Marriage Act 1920. It was provides for the permanent alimony and maintenance. It is like, unlike Section 24, which is 24 only deals with the interim maintenance during the pendency of the proceeding. Section 25 operates at the stage of passing a decree or any time subsequent thereto. It empowers the court direct the respondent to pay the applicant, whether wife or a husband, a gross sum or monthly periodical payment on a term not exceeding the life of the applicant. It is not exceeding life of the applicant. To determine the quantum of the alimony, first what is taken into consideration? The income and property of the respondent. One. Second, the income and the property details of the applicant. Third, the conduct of the parties. And the why conduct of party, you must have realized, any woman who is in adultery, she won't be getting that is by conduct of the parties. Or if she converted into Muslim, she is not, she will not get a maintenance as per the Hindu Marriage Act, and other relevant circumstances of the case. The provision also enables the court secure such payment by creating a charge on the immovable property of the respondent if necessary. Subsection 2 permits variation, modification or rescission of any order upon proof of the changes. If there are change in circumstances, court has a power to permit variation, permit modification and rescission. That is under Section 25(2). Okay. Suppose if further the wife remarries or doesn't remain chaste means she commits adultery, or then in that case husband engages in sexual relationship with outside wedlock, then that this type of change in circumstances will be taken into consideration while variation, while modification or any rescission of the order, when the proof of the same change in circumstances will put in before the honorable court. Now we will go to understand what do you mean by scope of under Section 25. The scope of under section, we will nicely clarify this section as such. We will take up of a case, Supreme Court judgment, Srimati Chand Dhawan versus Jawaharlal Dhawan, 1993, SCC 406. To understand what is the scope of this Section 25, is nicely explained. Supreme Court held that under Section 25 is not an independent source of maintenance. Supreme Court held that Section 25 is not an independent source of maintenance jurisdiction. It is an ancillary power that can be exercised only when a matrimonial court has done a passed a decree affecting affecting the matrimonial status, such as restitution of conjugal right, judicial separation, nullity, or a divorce. In this case, pendency, in this Dhawan case, Chand Dhawan case, the wife sought permanent alimony before the district judge in Amritsar, even though no matrimonial decree has been passed by the court. Your decree was not. What was the requirement? Decree has to be passed by alimony. The High Court held the application is not maintainable. The Supreme Court affirmed this view. This clarified that section 25 does not create a original or a stand-alone remedy for maintenance when the marriage remains subsisting and unaffected by the decree. So, under Hindu Marriage Act, if you want to apply for a permanent alimony under section 25, you should get a decree of divorce under nullity or under Hindu judicial separation or conjugal right. So, that is why it was nullified. This decree was it is not maintainable. Okay, we will now talk about the quantum, quantum also we spoke under Rajneesh versus Mehta, Rajneesh versus Neha. We talked about the quantum in the section 144 of BNSS and corresponding section 1. Here also there is a quantum which we will study with the one nice case law for Hindu Marriage Act. Determining the quantum under section 25 is guided by what? Principle of what? Justice, fairness, which we have seen. Justice, fairness and realistic assessment of the financial capacity of the individual person in the parties to the applicant, whoever is to go. We will take here case VK Vasanta Kumari versus R. Sudhakar 2014 SCC. In this case, the wife sought permanent alimony after the husband filed for divorce. The family court granted what? How much? 24 lakhs, which the Madras court enhanced to 40 lakhs. Reasoning that, what was the reasoning? That investment of 40 lakhs would yield approximately 40,000 per month. However, the wife argued before the Supreme Court that fluctuating interest rates will not consistently ensure the intended monthly income. The Supreme Court accepted this submission and held that quantum must effectively secure the maintenance deemed necessary by the court. To ensure a stable monthly support of rupees 40,000, court enhanced the permanent alimony to 55 lakhs. Previously by family court, how much it was granted? 24. Later on, Madras High Court, how much it enhanced to 40 lakhs. Then again to Supreme Court, it enhanced to 55 lakhs. This is a very beautiful case. Those who are on the side of women who are trying to get maintenance for securing maintenance for their party. VK Vasanta Kumari versus R. Sudhakar 2014 SCC 52. Okay. We'll take one more regarding permanent, one more case. Swarnalata versus Mohan Andrao Deshmukh. Andrao Deshmukh 2010 SCC 509. In this case, the husband obtained a divorce on the ground of wife's schizophrenia and remarried during the pendency of the process. Very nice judgment it is. The wife confined her claim to permanent, that is why the wife confined her claim under permanent alimony under section 25 of Hindu Marriage Act. The Supreme Court held that the claim was maintainable and justified. Why? Because wife has produced a list of husband assets, many of which were not denied. Okay. The court observed that the husband appeared sufficiently well off to provide suitable permanent alimony. However, since precise evidence was lacking, court refrained from fixing the lump sum immediately. Instead, it directed back again to the family court to record further evidence regarding the husband financial position before determining the amount. I hope this much is clear regarding the alimony. Okay. Now we will go to the section 25 to power to verify, modify or rescind. We all know what is the power to verify, modify. It is discretion given upon the authority given to the court to do all this in the permanent alimony if there is a material change in circumstance. So we will understand this with one small case law. What do you mean by material change in with the example of one case law, circumstance in the parties? The scope of section 25(2) was examined by the Supreme Court, in which case a Kalyan De Chaudhary versus Rita De Chaudhary 2017-14 SCC 200. Okay, the parties were remarried in the 1995 and had a son born in 1996. Their relations soon deteriorated, leading to multiple proceedings, including claims for restitution of conjugal right, judicial separation, criminal complaints, and the maintenance. Initially, in the year 2006, the wife was awarded a permanent alimony of rupees 2,500 per month. Over a period of time, the amount was enhanced to successive proceeding. In 2000, wife filed application under 20.2 seeking further enhancement in the ground of increased needs and the change circumstances. The family court again granted 6,000 each to the wife and the son. The High Court subsequently enhanced the amount from to 16,000 per month. Upon review, further increased to 23,000 per month. The husband, that is why the husband challenged this enhancement done before the Supreme Court, contending that the increase was excessive and that he has remarried and incurred additional responsibilities. Then the Supreme Court clarified in section 25(2) that it does not permit routine reconsideration of the maintenance. The statutory requirement is explicit. The court must be satisfied that there has been a change in circumstances of either of the party. Modification justified only when there is a material change occurs. There should be material change, like his salary should be increased, or his business is today turnover is 1 crore, it should be 2 crores or 5 crores, or suddenly he got a lottery around 100 crores. So there also she can say change in circumstances. Such a substantial increase or decrease in income, additional financial, and also since he's married, there is an additional financial obligation he's having because he has to take care of another wife. The second wife he has married after this decree of the divorce decree, and the children born into that matrimonial cord which he is having, or enhanced need of the claimant. In the present case, the court noted that husband's salary has significantly increased from 2015 to there is an increase in salary, no doubt of it. Therefore, enhancement is justified. However, there is he took into account the remarriage. Though his income is increased, but what is happened? New thing is happened. The new marriage is happened in this man's life, and the responsibility of maintaining that wife, second marriage, and the child is a great obligation on him. Though his salary is balancing these factors, balance approach is always done by the judiciary. The Supreme Court reduced the High Court award from 23 to rupees 20,000 per month. I hope with this we understood what are the power to verify, modify, and when the court exercise this jurisdiction. Only when there is a regarding the change in the material change in the records. What about the survival of decree after that? Suppose the decree is passed and the person who was paying, husband who was paying, dies, then what will? So we will understand this concept with a very beautiful case, Mrs. Aruna Basu Mulik versus Dhoreta Mitra, a 1983 SCC 522. Here the court addressed this issue directly. It held that object of permanent alimony provision is to protect the wife from destitution, from material disruption. If the husband leaves behind estate, there is no justification of allowing his has to inherit the property free from the obligation to sell. Means uska property, if he is having some properties there, then property will be developing on the legal heads. That decree is passed. Then court observed here that although matrimonial proceedings themselves abate upon the death of their either spouse, a decree already passed stand on the same footing as any other civil decree. Means decree, if it is passed for the woman, and that doesn't mean that decree will become obsolete. It will not become. It will be as a same civil decree, which will be enforceable against the estate of the deceased in the hands of legal representatives. He should have some estate. If that estate is been taken over by of his other family members, they are bound to obliged to pay maintenance from that amount which his husband was having those assets. But if he's not having estate, then he will not get anything. Tenga. Thus, the decree of permanent alimony creates a legally enforceable liability that survives the death of the husband and binds his estate. Obligation does not perish with the person. It attaches behind them the property left behind. I hope with this you got a clarity of the Hindu Maintenance Act. Now we will go to Hindu Maintenance under Adoption and Maintenance Act 1956. what this act says. This act imposes. So there are so many. Here also they can claim maintenance, but here also, what are the extra thing? We should only know that we have understood now. Quantum we understood. What is the status to be understood? Status quo. What should be? How we have to derive those amount figure? We understood when we can resign, when we can when the maintenance is incomplete. That everything we understood now. Now, what is so important is then Hindu marriage. Why anybody should go under this? Why this act is actually first of all came into the place? We have the under section. So here act imposed what? Obligation on Hindu. It is obligation only on Hindu religion, Hindu man or Hindu family to maintain what? Certain close relatives. Okay, not only husband, wife and all, it is a close relative, it includes in that wife, minor sons, minor unmarried daughters. Okay, minor sons. So if a son, it is minor sons. Daughter can be minor or can be major. Till then she need a support. She will have to be given maintenance. And the aged parents. The obligation is personal in nature and arises from the very relationship between the parties. Now, in the section 80 of Hindu adoption and maintenance, it is with what maintenance the rights of the Hindu wife under section 8, especially in section 18, it deals with only maintenance of wife, Hindu wife, whether married before or after the commencement of this act. It is entitled to maintain by her husband during her lifetime. The right to maintain is regarded as an incident of matrimonial status. Here, right to separate residence and maintenance is there in section 18(2), subsection 2. Recognizes that certain circumstances may justify a wife living separately from her husband without losing her right to maintenance. The provision enumerates specific grounds on which wife can claim. When she can claim, one is first, there should be desertion by the husband. Meaning of abandonment with reasonable cause should be there without wife consent or against her wishes. She is deserted. Second, cruelty where the husband conduct a cause or reasonable apprehension that living with him will be harmful or injurious, that she should be able to prove before the court. Secondly, existence of another wife if there, where the husband has another wife living along with them, then also she can claim for maintenance. Keeping a concubine either in the same house or by habitually residing with someone else person, then also she can claim for maintenance over here. And the conversion of husband into another religion, resulting him ceasing to be Hindu, then also she can claim for maintenance. Or any other justified cause that makes it reasonable for the wife to live separately, which we have when she can claim for a maintenance, even she lives separately, which we have covered in the previous part 1 lecture for the under section 144 BNSS. Here we'll take one beautiful case, that is Rohini Kumari versus Narendra Singh, AIR 1972 SC 459. In this case, the Supreme Court held that the wife is not required to seek judicial separation or a divorce in order to claim the maintenance while living separately. It is established that the husband has been guilty of desertion or any other ground specified above in 18(2). If there's all the ground are there, wife may live separately and still claim for maintenance from her husband. So in this, but here there are limitations for this maintenance. What are the limitations? Wife is not entitled for a separate when if she is unchaste or she ceases to be Hindu by converting herself into another. Two places she is not entitled when she is once unchaste. If she is unchaste, she lives in adultery. Or second, she is chases to be Hindu if she convert herself into Muslim. So thus section 18 may be read as a where wife may be lived separate by claiming maintenance, and subsection 3 for the limitation laid down the exception. This is exceptions are raised in what? 18(3). 18(2), she can claim for the what are the justified reasons she can claim for the maintenance. Now we have understood in the previous lecture was the relationship between the section 144, that is a secular section, with the personal law. In this we will now we will try the relationship between the Hindu Adoption and Maintenance Act with the section of 144 BNSS or corresponding section what we have earlier doing, section 120 of CRPC. Here, right to maintenance under Hindu adoption and maintenance operates along the remedy provided under Section 125 of Civil Procedure Code. Section 125 provides a summary and a secular remedy intended to what? Prevent destitution and vagrancy. We will take two cases over here to understand this concept of relationship between the Hindu Marriage Adoption Act and Section 144 of the BNS. In corresponding Section 125 CRPC, in Savita Ben Somabhai Bhatia versus State of Gujarat, AIR 2005, SC 1809. Here, the Supreme Court clarified the relationship between the provision. The court held that there is no inconsistency between the 125 of the code and the provision of Hindu Adoption and Maintenance Act. This is clear. The scope of the two laws is different. The scope is different, but Section 120 functions as a secular and summary remedy, independent of the personal laws, designed to provide quick relief to the person unable to maintain themselves. So what is the basic difference? Section 124 or BNS 144 is a secular remedy and independent to any of the personal laws. So it provides a quick remedy. And here it is no way to, this scope of the two laws is different. Both laws section scope is different. And in Supreme Court, one more to elaborate it in relationship between the remedies is Nagendrappa Natikar versus Nilamma 2014 SCC 452. In this case, the parties had earlier entered into a compromise in proceeding under Section 125 CRPC, where the wife agreed to accept a lump sum amount as a permanent alimony and waive all her further claim. Very interesting case, please note. Waive all her future claim for the maintenance. Subsequently, the wife filed a suit under Section 18. Subsequently, after she told that she waived all her rights, and subsequently after getting the permanent alimony under Section 125 CRPC earlier, now it is known as 144 new BNSS. Subsequently, wife filed a suit under Section 18 of Hindu Adoption and Marriage Act claiming maintenance. Got? Very interesting code. Here what Supreme Court did? Supreme Court held that a suit under Section 18 was maintainable despite the earlier compromise. I hope this is one of the wonderful Supreme Court judgment, and if anybody was not knowing, you will find it. You are blessed today if you got to hear today. The court observed that Section 125 CRPC provides only a summary and a tentative relief, and it is not intended to finally determine the civil rights and obligation of the parties. Such right may be still be adjudicated into proper civil proceedings. Got it? So with that, we understood the relationship between the Hindu Adoption and Marriage Act and under Section 125 of CRPC, and now known as 140 BNS. Now we will go to maintenance of widow daughter-in-law, that is under Section 19. So widow daughter also, how she can claim maintenance. Widow daughter too can maintenance from the under this section under Hindu Adoption and Marriage Act. Okay. Then maintenance of aged parents also can be asked into Hindu adoption. That also can be asked into Section 144 now, and previously it was 125 CRPC. That is under Section 20. Under Section maintenance of children and aged parents can be also claimed as a maintenance into as per this act. Under Section 19 of Hindu Marriage and Adoption also widowed daughter-in-law can also claim maintenance. Okay. One important nice case I will cover here specifically. Padmaja Sharma versus Ratan Lal Sharma, AIR 2000 SC 1398. Here the court rejected the assumption that the responsibility for maintaining children rests exclusively upon the father. It held that both parents are equally bound to contribute towards the maintenance of the minor children. Where both parents are earning, the liability must be apportioned in the proportion to their corresponding or respective income. So whenever you want to regarding the quantum you have to decide, then you have to decide the both persons' earnings. So this case will be very helpful those who are practicing in matrimonial cases. Okay. One more very important case I will cover up for you. One, write down very, very beautiful case. Kirtikant Vadoraya versus State of Gujarat, 1996, 4, SEC 4. In this, court held, please appreciate the beauty of this. The court held that a childless stepmother who is unable to maintain herself may claim maintenance from the stepson, where her husband lacks to means to support her. Or Kirtikan D. Vadodara versus State of Gujarat, 1996, SCC 417, where her stepson also has to maintain if her father is, his father is not able to support her stepmother. Then maintenance of dependent as also can be claimed over here. That is section 20. Who are the dependent means dependent can be father, mother, widow, minor son, grandson, married daughters, granddaughters, then widowed daughters, and the widows of sons or grandsons who remain unmarried. They all covers under this Maintenance of Adoption and Maintenance Act. Whether illegitimate son, whether married, unmarried. Illegitimate children also covered under Hindu Adoption and Marriage Act. So obligation of heirs to maintain dependents. Suppose there are legal heirs and the claimant didn't get anything from that ancestral property, inherit property from there, they are bound to provide obliged to pay maintenance under section 22 imposed on the Hindu Adoption and Marriage. In that, I will cover one small case law. That is a Balwant Kaur versus Chanan Singh, 2000 Supreme Court. The Supreme Court held that once a person is established as an independent, he or she possesses a pre-existing right against the estate of the deceased to claim maintenance. Okay. And determination amount of maintenance we have already covered. And with final conclusion of this case, with this maintenance part, we will take one Kulbhushan Kumar. Kulbhushan Kumar versus Raj Kumari, AIR 1997 SC 234. The court observed that the maintenance cannot be determined through a rigid or a mathematical formula. Instead, it depends upon the facts and the circumstances of each case. The court further clarified financial assistance voluntarily received from relatives, such as occasional support from the claimant parents, cannot be treated as income for the purpose of reducing maintenance. It also approved that approach of assessing maintenance with reference to husband-free income, that is, income remaining after deduction of essential expenses such as taxes, provident fund contribution, and the professional cost. In that means even if some help is given by the mother-in-law or by sister, that doesn't come into, that cannot be come into calculation of maintenance. And regarding eligibility, it is the last part, section 24, where who are eligible. The person who has converted to another religion is ceased to be entitled to maintenance under this provision. Okay. Then modification can be done in section 25, and the charge, and then one more concept is a charge on the property, that is under section 27. If you want to create a charge on the property of the other person, it also can be created under section 27 of Hindu Adoption and Marriage Act. And with this, we wind up with this Hindu adoption maintenance is one case we will take. Siddha Gayang versus N.K. Giri Raja Shetty. It's a civil appeal at 5007-2018. Here the Supreme Court explained that section 28 balances the protection of the dependent with the need to be safeguard genuine property transaction. The court also observed that where a suit for maintenance seeking the creation of a charge on a specific property is pending, any transfer made during the pendency of the suit will be governed by the doctrine. Which doctrine? Lease pendens under section 52 of the Transfer of Property Act, as a right to immovable property is directly in question. So hope I was enough helpful while giving you this small topic covering up all the matters under Hindu Marriage Act and Hindu Adoption and Marriage Act. And thank you so much, LD Lawyers Forum, for giving me the privileges. And if any questions are there, can we raise a
Yes, well, there have been some participants who have dropped the question in the chat box, and some have raised their hands. Maybe we can walk through the raised hands first.
Yes.
Vivek Chakrani sir, Hiralal Gohil, and M.A. Sheikh sir. Please post your questions so that ma'am can answer quickly. Vivek Jakkani, sir. Hiralal Gohil, sir. Anybody? 1 minute. I'll just quickly adjust the settings.
Hello.
Hello. Yes, I can hear you.
Yeah. Good afternoon, ma'am. Thank you very much.
Yeah, good afternoon. Thank you.
My question is that under
Okay.
the change of circumstances, if a
Okay.
wife changes religion, so it comes under the circumstances.
Change in the circumstances. See, change of circumstances basically based on the income when it is considered. If she changes, she is not disqualified. She is disqualified from claiming any maintenance as per the Hindu Marriage Act or Hindu Adoption Act. She is disqualified. There is no question of maintenance. Change in circum when the person is granted some interim maintenance and then they are giving maintenance on that. Suppose his husband income today in this year is around 1 crore. He may rise it to 2 crores also. He may come down to 50 lakhs also based on the circumstance. Or if he married, which we have covered in one case of previously, if he remarries, then extra obligation also to be taken into account. Then that time the balance approach is seen. Even his income is increased. That doesn't mean that he'll able to pay because he has addition obligations and responsibilities come into his life after the decree filed.
Thank you, madam. In my case, the wife is professing other than the Hindu. She is by
She is
birth Hindu.
disqualified. She is disqualified from